to discuss with you the budget. This budget was passed by Donald Trump on May the 5th, 2017. That was the original date that the original budget, H.R. 244, Consolidated Appropriations Act of 2017, became the law. On February the 9th, Donald Trump just signed anything, H.R. 1892. It became law. So what he's basically saying inside of this is that on February the 9th, 2018, the president signed into law H.R. 1892, the Bipartisan Budget Act of 2018, which authorized the United States flag to be flown at half-staff in the event of the death of a first responder in the line of duty. This is the most important piece right here. Division B of the enrolled bill provides additional emergency supplemental appropriations related to recent hurricanes, wildfires, and disasters, including tax relief and Medicaid changes. Division B also includes a short-term continuing resolution that provides fiscal year 2018 appropriations for continuing projects and activities of the federal government through Friday, March 23rd, 2018. Division C also establishes two joint select committees, a committee to improve the solvency of multi-employer pension plans, and a committee to provide recommendations on reforming the budget and appropriations process. Temporarily suspends the statutory debt limit through March 1st, 2019. Division D of the enrolled bill extends provisions that provide tax relief to families and individuals, provides incentives for job growth, and incentives for energy production and conservation. Division E of the enrolled bill extends or modifies Medicare, Medicaid, and other health programs, including various foster care and child welfare programs, and includes various offsets related to Medicare, Medicaid, and other health programs. Division F of the enrolled bill includes agricultural programs improvements for cotton, livestock, and dairy producers. Division G of the enrolled bill includes direction regarding the budgetary effects of Division A. Subdivision 2 of Division B, Division C, and each succeeding division. Additional information regarding these provisions can be found in the attachment. Now, there is no attachment to this bulletin that he placed up here. So we're going to go here to the bill. This is Division B, Title 2. I'm going to Title 2 because I'm not for certain how long I'll have access or connection so that I can get through this. But anyway, up under Division B, Title 2, the Department of Justice, for expenses necessary for administration of the Department of Justice, $114 million, of which not to exceed $4 million for security and construction of Department of Justice facilities shall remain available until expended. Justice Information Sharing Technology, for necessary expenses for information sharing technology, including planning, development, deployment, and departmental direction, $31 million to remain available until expended, provided that the Attorney General may transfer up to $35 million to this account from funds available to the Department of Justice for Information Technology to remain available until expended for enterprise-wide information technology initiatives, provided further that the transfer authority in the preceding proviso is in addition to any other transfer authority contained in this act, provided further that any transfer pursuant to the first proviso shall be treated as a reprogramming under Section 505 of this Act and shall not be available for obligation or expenditure except in compliance with the procedures set forth in that section. Executive Office for Immigration Review. I needed to focus. Come on and focus. Let's see if I move it, will it focus? I'm not for certain why it's not focusing. There it is. Okay. Okay, so it went down a little bit too far. So let's go back up, because this is important. This right here is really important. It took me, I went all the way back up to the beginning of Division B, which is just the Commerce, the Justice, Science, and Related Agencies Appropriations Act 2017. Okay, so I'm going back down to Title II. That was Title I. And trying to get it to focus, I moved it around, and I enlarged it a little bit, and it it moved the entire text. So this is the Department of Justice where we left off, down here by the Executive Office for the Immigration Review, and we left off where for the expenses necessary for the administration of immigration-related activities of the Executive Office for Immigration Review, $440 million, of which $4 million shall be derived by transfer from the Executive Office for Immigration Review fees deposited in the Immigration Examinations fees account, provided that not to exceed $15 million of the total amount made available under this heading shall remain available until expended. Provided further that any unobligated balances available from funds appropriated for the Executive Office of Immigration Review under the heading General Administration, Administrative Review, and Appeals shall be transferred to and merged with the appropriation under this heading. For the Office of the Inspector General, for necessary expenses of the Office of Inspector General, $95 million, including not to exceed $10,000 to meet unforeseen emergencies of a confidential character. I'm going to scroll down here and get to the part that concerns me a lot, because excuse me, this budget bill is using taxpayer funds to pay for things like this: state and local law enforcement activities, Office on Violence Against Women, Violence Against Women Prevention and Prosecution programs, including transfer of funds for grants, contracts, cooperative agreements, and other assistance for the prevention and prosecution of violence against women, as authorized by the Omnibus Crime Control and Safe Street Acts of 1968. The Violent Crime Control and Law Enforcement Act of 1994, the Victims of Child Abuse Act of 1990, the Prosecutorial Remedies and Other Tools to End the Exploitation of Children Today Act of 2013, the Juvenile Justice and Delinquency Prevention Act of 1974, the Victims of Trafficking and Violence Protection Act of 2000, the Violence Against Women and Department of Justice Reauthorization Act of 2005, the Violence Against Women Reauthorization Act of 2013, the Rape Survival Child Custody Act of 2015, and for related victims' services, $481,500,000 to remain available until expended, of which $326 million shall be derived by transfer from amounts available for obligations in this act from the fund established by Section 1402 of Chapter 14 of Title II of Public Law 98-473, notwithstanding Section 1402D of the Act of 1984, and merged with the amounts otherwise made available under this heading, provided that, except as otherwise provided by law, not to exceed 5% of funds made available under this heading may be used for expenses related to evaluation, training, and technical assistance, provided further that of the amounts provided, $215 million is for grants to combat violence against women, as authorized by Part T of the Act of the 1968 Act. $30 million is for transitional housing assistance grants for victims of domestic violence, dating violence, stalking, or sexual assault as authorized by Section 40-299 of the 1994 Act. $3 million is for the National Institute of Justice for research and evaluation of violence against women and related issues addressed by grant programs of the Office on Violence Against Women, which shall be transferred to research evaluation and statistics for administration by the Office of Justice Programs. $11 million is for a grant program to provide services to advocate for and respond to youth victims of domestic violence, dating violence, sexual assault, and stalking, assistance to children and youth exposed to such violence, programs to engage men and youth in preventing such violence, and assistance to middle and high school students through education and other services related to such violence, provided that unobligated balances available for the program authorized by Sections 41-201, 41-204, 41-303, and 41-305 of the 1994 Act, prior to its amendment by the 2013 Act, shall be available for this program, provided further that 10% of the total amount available for this grant program shall be available for grants under the program authorized by Section 2015 of the 1968 Act, provided further that the definitions and grant conditions in Section 40-002 of the 1994 Act shall apply to this program. $53 million is for grants to encourage arrest policies as authorized by Part U of the 1968 Act, of which $4 million is for a homicide reduction initiative. $35 million is for sexual assault victims assistance as authorized by Section 41-601 of the 1994 Act. $35 million is for rural domestic violence and child abuse enforcement assistance grants as authorized by Section 40-295 of the 1994 Act. $20 million is for grants to reduce violent crimes against women on campus as authorized by Section 304 of the 2005 Act. $45 million is for legal assistance for victims as authorized by Section 1201 of the 2000 Act. $5 million is for enhancing training and services to end violence against and abuse of women in later life as authorized by Section 4802 of the 1994 Act. $16 million is for grants to support families in the justice system as authorized by Section 1301 of the 2000 Act, provided that unobligated balances available for the programs authorized by Section 1301 of the 2000 Act and Section 41-002 of the 1994 Act, prior to their amendment by the 2013 Act, shall be available for this program. $6 million is for education and training to end violence against and abuse of women with disabilities as authorized by Section 1401 of the 2000 Act. $500,000 is for the National Resource Center on Workplace Responses to assist victims of domestic violence as authorized by Section 41-501 of the 1994 Act. $1 million is for analysis and research on violence against Indian women, including as authorized by Section 904 of the 2005 Act, provided that such funds may be transferred to research, evaluation, and statistics for administration by the Office of Justice Programs. $500,000 is for a national clearinghouse that provides training and technical assistance on issues relating to sexual assault of American Indian and Alaska Native women. $4 million is for grants to assist tribal governments in exercising special domestic violence criminal jurisdiction as authorized by Section 904 of the 2013 Act, provided that the grant conditions in Section 440-002B of the 1994 Act shall apply to this program, and $1,500,000 for the purposes authorized under the 2015 Act. Office of Justice Programs, Research, Evaluation, and Statistics, including transfer of funds for grants, contracts, cooperative agreements, and other assistance authorized by Title I of the Omnibus Crime Control and Safe Street Acts of 1968, the Juvenile Justice and Delinquency Prevention Act of 1974, the Missing Children's Assistance Act, the Prosecutorial Remedies and Other Tools to End the Exploitation of Children Today Act, the Justice for All Act of 2004, the Violence Against Women and Department of Justice Reauthorization Act of 2005, the Victims of Child Abuse Act 1990, the Second Chance Act of 2007, the Victims of Crime Act of 1984, the Adam Walsh Child Protection and Safety Act of 2006, the Protect Our Children Act of 2008, Subtitle D of Title II of the Homeland Security Act of 2002, the NICS Improvement Amendment Act of 2007, the Violence Against Women Reauthorization Act of 2013, and other programs, $89 million to remain available until expended, of which $45 million is for criminal justice statistic programs and other activities that's authorized by Part C of Title I of the 1968 Act, of which $5 million is for a nationwide incident-based crime statistic program. $39 million is for research, development, and evaluation programs and other activities as authorized by Part B of Title I of the 1968 Act and Subtitle D of Title II of the 2002 Act, of which $4 million is for research targeted toward developing a better understanding of the domestic radicalization phenomenon and advancing evidence-based strategies for effective intervention and prevention, and $4 million is for activities to strengthen and enhance the practice of forensic science, of which $3 million is for transfer to the National Institute of Standards and Technology to support scientific area committees. State and local law enforcement assistance for grants, contract, cooperative agreements, and other assistance authorized by the Violent Crime Control and Law Enforcement Act of 1994. They're going to read all of these acts over again, and then here's a new one right here. The Prioritizing Resources and Organization for Intellectual Property Act of 2008, the Victims of Crime Act of 1984, the Mentally Ill Offender Treatment and Crime Reduction Reauthorization and Improvement Act of 2008, the Violence Against Women Reauthorization Act of 2013, the Comprehensive Addiction and Recovery Act 2016, and other programs, $1,258 million to remain available until expended as follows. $396 million for the Edward Byrne Memorial Justice Assistance Grant Program as authorized by Subpart 1 of Part E of Title I of the 1968 Act, except that Section 1001C and the special rules for Puerto Rico under Section 505G of the Title I of the 1968 Act shall not apply for purposes of this Act, of which notwithstanding such subpart 1, $7 million is for the Officer Robert Wilson III Memorial Initiative on Preventing Violence Against Law Enforcement Officer, Resilience and Survivability. $5 million is for an initiative to support evidence-based policing. $2.5 million is for an initiative to enhance prosecutorial decision-making. $2.4 million is for the operationalization, maintenance, and expansion of the National Missing and Unidentified Persons System. $2.5 million is for the National Training Initiative to improve police-based responses to people with mental illness or developmental disabilities. $6.5 million is for competitive and evidence-based programs to reduce gun crime and gang violence. $2 million is for a student loan repayment assistance program pursuant to Section 952 of Public Act 110. 2.5 million is for the Capital Litigation Improvement Grant Program as authorized by Section 426 of Public Law 108, and for grants for wrongful conviction review. 10.5 million is for prison rape prevention and prosecution grants to states and units of local government and other programs as authorized by the Prison Rape Elimination Act of 2003. And 20 million is for the sole purpose of providing reimbursement of extraordinary law enforcement and related costs directly associated with protection of the president-elect incurred from November 9, 2016 until the inauguration of the president-elect as president. You see how they stuck that in here? They stuck that $20 million in there. $20 million is for the sole purpose of providing reimbursement of the extraordinary law enforcement and related costs directly associated with the protection of the president-elect incurred from November 9, 2016 until the inauguration of the president-elect as president, provided that reimbursement under the foregoing shall be provided only for costs that a state or local agency can document as being over and above normal law enforcement operations and directly attributable to the provisions of protection described herein. Provided further that Section 154 of the Continuing Appropriations Act 2017, Division C of Public Law 114, as amended by the further Continuing and Security Assistance Appropriations Act 2017, is amended by inserting after $7 million the following to remain available until September 30th, 2017. $210 million for the State Criminal Alien Assistance Program as authorized by Section 241 I-5 of the Immigration and Nationality Act, provided that no jurisdiction shall request compensation for any cost greater than the actual cost for federal immigration and other detainees housed in state and local detention facilities. $45 million for victim services programs for victims of trafficking as authorized by Section 107B2 of Public Law for programs authorized under Public Law 109 or programs authorized under Public Law 113. $13 million for economic, high technology, white collar, and internet crime prevention grants, including as authorized by Section 401 of Public Law 110. $20 million for sex offender management assistance as authorized by the Adam Walsh Act and related activities. $22 million for the matching grant program for law enforcement armor vests as authorized by Section 2501 of Title I of the 1968 Act, provided that $1.5 million is transferred directly to the National Institute of Standards of Technology's Office of Law Enforcement Standards for research, testing, and evaluation. $1 million for the National Sex Offender Public Website. $73 million for grants to states to upgrade criminal and mental health records for the National Instant Criminal Background Check System, of which no less than $25 million shall be for grants made under the authorities of the NICS Improvement Amendments Act of 2007. $13 million for the Paul Coverdale Forensic Science Improvement Grants under Part BB of Title I of the Act 1968. $125 million for DNA-related and forensic programs and activities, of which $117 million is for a DNA analysis and capacity enhancement program and for other local, state, and federal forensic activities, including the purposes authorized under Section 2 of the DNA Analysis Backlog Elimination Act of 2000. The Debbie Smith DNA Backlog Grant Program, provided that up to 4% of funds made available under this paragraph may be used for the purposes described in the DNA Training and Education for Law enforcement, correctional personnel, and court officers program up under the Public Law 108. $4 million is for the purposes described in the Kirk-Bloodsworth post-conviction DNA testing grant program, and $4 million is for sexual assault forensics exam program grants, including as authorized by Section 304. $45 million for a grant program for community-based sexual assault response reform. $9 million for the court-appointed special advocate program as authorized by Section 217 of the 1990 Act. $68 million for offender reentry programs and research as authorized by the Second Chance Act of 2007, without regard to the time limitations specified in Section 6, number 1 of such act, of which not to exceed $6 million is for a program to improve state, local, and tribal probation or parole supervision efforts and strategies. $5 million is for children of incarcerated parents, demonstrations to enhance and maintain parental and family relationships for incarcerated parents as a reentry or recidivism reduction strategy. And $4 million is for additional replication sites. Excuse me. Excuse me. It's for additional replication sites employing the Project Hope Opportunity Probation for enforcement model implementing swift and certain sanctions in probation, and for a research project on the effectiveness of the model, provided that up to $7.5 million of funds made available in this paragraph may be used for performance-based awards for pay for success projects, of which up to $5 million shall be for pay for success programs implementing a permanent supportive housing model. $50 million for the Comprehensive School Safety Initiative. $65 million for initiatives to improve police community relations, of which $22 million is for a competitive matching grant program for purchases of body-worn cameras for state, local, and tribal law enforcement. $25 million is for a justice reinvestment initiative for activities related to criminal justice reform and recidivism reduction, and $75.5 million is for an Edward Byrne Memorial Criminal Justice Innovation Program, and $103 million is for comprehensive opioid abuse reduction activities, including as authorized by CARA, and for the following programs, which shall address opioid abuse reduction consistent with underlying program authorities. $43 million for drug courts as authorized by Section 101A of the Title I of 1968 Act. $12 million for mental health courts and adult and juvenile collaboration program grants as authorized by Parts 5. Excuse me. I have to sit there for 1 minute. It's 6 o'clock in the morning. I'm sorry. Okay. I just had to let it sit there for a minute. The $12 million, well, in number B, $12 million for mental health courts and adult and juvenile collaboration program grants, as authorized by Part 5. And double H of Title I of the 1968 Act and the Mentally Ill Offender Treatment and Crime Reduction, Reauthorization, and Improvement Act of 2008. $14 million for grants for residential substance abuse treatment for state prisoners, as authorized by Part S of Title I of the 1968 Act. $7 million for a veterans treatment court program, and $14 million for a program to monitor prescription drugs and scheduled listed chemical products, provided that if a unit of local government uses any of the funds made available under this heading to increase the number of law enforcement officers, the unit of local government will achieve a net gain in the number of law enforcement officers who perform non-administrative public sector safety services. And then it goes on to talk about the juvenile justice programs, about how much money they're going to be spending for our kids. And I'm not understanding why. What is the purpose behind this? Why is all of this money being spent to protect women, and protect women from what? What is getting ready to happen? Okay. From I'm just scrolling through some of the titles. And right here up under the community oriented policing services, I'm going to let that sit there for 1 minute. And just talk about what I'm reading into. What I'm reading into this is that I guess they're preparing their militia to wage, I guess it's like a war against the people, because they're preparing for us to, well, they call it an insurrection. Well, we're going to be out there in the streets like crazy once all of this stuff do happen, because it's not only going to happen to minority people, it's going to happen to poor people, it's going to happen to all people. If you're not in the 1%, it's going to happen to you. Whether you're black, white, whatever color, whatever race, nationality you are, it's going to happen to you. You can hear it if you're watching any type of news broadcast station, and you hear Jeff Sessions talking, then you know you basically have an idea of where they're going with this. This is in an attempt to decrease the population, for one. Is also to enact their law to bring back slavery. Not slavery only for black people. It's for all the poor people. All the poor people, anybody that own any debt, any student loans, any child support, any you have any IRS debt, if you have any debt at all, they're coming for you. They're coming for you. And all of this stuff is written in this bill. This is I've always said that this is the most inhumane, horrific piece of legislation that any human have ever written. And I'm just not really, I'm not understanding this. I'm not understanding how members of Congress is allowing this to happen. Any of our elected officials who supported this bill and assisted it to become law, they are in violation of their oath of office. They are in violation of their oath of office. And not only that, they are advocating the overthrow of our constitutional form of government to implement their constitution. And their constitution is basically taking precedence over everything right now. But I wanted to put this out here. This is the This is the HR 244 Consolidated Appropriations Act. Let it come into focus. It'll come into focus. Come on, so they can see. And this it became law May the 5th, 2017. Let's see if we can pull up all the actions. Now, all of the actions up under here are basically from McConnell. McConnell they used him to put his name on a lot of this stuff. We're gonna show all of the. I want to show all of the actions, going back from the very beginning. Okay. Excuse me. They introduced this in the House January the 4th, the day after they took their oath of office. January 3rd was the very first day that this 115th session came to order. And that was the very first day when they implemented House Resolution 5, changing the House rules. And they also used that HR House Resolution 5 to change the laws. But anyway, these are the dates in which it was supposed to have traveled through both houses. So on February the 13th, I don't know who Mr. Billirakis is, but he moved to suspend the rules and pass the bill as amended. Now, this bill went through a lot. It went through a whole lot of changes and revisions and amendments. But throughout this whole thing, it was just a few of them that always suspended the rules so that they can pass this and make it law. And that's what happened. They did that. They suspended the rules and they made it a law. You see, on the 13th, at the conclusion of the debate, the yeas and nays were demanded and ordered pursuant to the provisions of Clause 8, Rule 20. The chair announced that further proceedings on the motion would be postponed. So they didn't give them what they asked for. They didn't give our elected officials what they asked for. And they wanted to know who voted for this. They had a right to know this, but throughout this whole ordeal, they kept suspending the rules. See, on a motion to suspend the rules and pass the bill, as amended, agreed to by now they saying that the yeas and nays, that 2/3, it was only required 2/3 of yeas, but that's not what happened. But anyway, I wanted to see Mitch McConnell also. They done took his name out of here because Mitch McConnell's name was in here a lot, where he did a whole lot of passing the suspending the rules to pass the bill. So apparently it got back to the Rules Committee where they introduced a House Resolution number 305, and that's got some amendments in it. Excuse me. Move it a little bit so it can clear up, because I really need for you all to see this. I'm hoping it's not blurry when if it's showing. I'm hoping that it's not blurry, because this right here is really important. Okay, but anyway, here we come with McConnell. Where he just does a lot. He's invoking cloture, and he's suspending rules and passing them laws, and he's making amendments, and these amendments he making trying to he amended the amendments that were made. Now, anytime one of our elected officials, like I think she's Representative Black, she wrote HR House Joint Resolution 71. And she cut out everything they did. And they went right behind her. They took that resolution and made it their own. They just, we need to stop them. We do. So let me let you all go with this, because there is other things in here I need for you all to see. Like this the Constitution. I'm gonna find it right here. And I want you all to see the I want you all to see the way they did the codes, the law codes too. Okay, up under here, I keep telling everybody that we're worrying about an election that it's not gonna really matter, because they amended the laws and gave themselves total control. They have total control. Excuse me. I'm hoping you all can see this. If not, this is in the National Archives. Let me see. The National Archives. But anyway, down here in Article 1, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. No person shall be a representative who shall not have attained to the age of 25 and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of the state in which he shall be chosen. Representatives and direct taxes shall be apportioned among the several states which may be included within this union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed 3/5 of all of other persons. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made, the states of New Hampshire shall be entitled to choose 3, Massachusetts 8, and Rhode Island and Providence Plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. When vacancies happen in the representation of any state, the executive authority thereof shall issue writs of election to fill such vacancies. The House of Representatives shall choose their speaker and other officers, and shall have the sole power of impeachment. Pay attention to this. The House of Representatives shall choose their speaker and other officers. This is what they're telling you. It don't matter who you're putting in, who we vote for. Just like what's happening now, if our elected officials would just go ahead and be honest, just be honest about them delegates that they done put in. They selected civilian people to take over the positions of our elected officials. This is why don't nobody know anything. I wish they would go ahead and just be honest and let us know. Congress, Paul Ryan, Mick Mulvaney, the director of Office and Management and Budget, Kevin McCarthy, Mitch McConnell, Orrin Hatch, Michael Pence, and Donald Trump, we should not have to wait until Congress decide to impeach them, because that's never going to happen. It's not going to happen. Impeachment will not happen because Paul Ryan is in cahoots with those members in the White House. They're all in cahoots. And the only way we can get rid of them is that we have to demand that our elected officials in there right now, they have to remove them. They have to remove them up under 18 USC 1918, Title 5, 7311, for advocating the overthrow of our constitutional form of government. They have to do it that way. Otherwise, we're going to be in trouble. We keep sitting back here. We're not seeing anything. We're watching we're watching the clown show Trump. We're watching them talk about the Russia. To hell with the Russians. We worrying about the United States of America. To hell with that election, because they know that election should have been null and void. It should have not even gotten to this point. Period. Regardless to who's ever at fault, whether it was the Russians who hacked our system, or whether it was the Americans who hacked our system, or was it the Russians who gave the Americans the capabilities to hack our system. Whatever the case may be, Trump should not have been in there. He should not. The election was not won by the people. He did not win by the people. Actually, Hillary Clinton won that election by the majority vote. The majority vote. But anyway, getting back to this Constitution, I'm gonna go ahead and end this, but I'm gonna make another one, because the content of this spending bill is not only I'm just at a loss. I'm at a loss for words. I am truly at a loss for words, because every division in this bill is punitive. It's punitive for the people. They're using our tax dollars and taking our rights to life, liberty, and the pursuit of happiness. They're doing this to us, and we're not saying anything. It's time for us to start speaking up. I'm going to leave this here, and I'll get back to you.